Okay, hello everybody. We're going to wait for some people to get in before we start. Hello everybody joining. Please hit that like button so it sends some notifications out that we are live and we're going to discuss what happened with this pop-up hearing for Barry Morphew today. Hello, Just Treasure Trunk. Hello, Maui Girl. How is everybody today? Again, please smash that like button. Let everybody know that we are live. It helps with the algorithm. And it's been an interesting hearing, to say the least. So I'm going to get into this, what exactly transpired in this hearing. I'm going to go over everything that was brought up. So those of you who did watch the hearing, I'm going to ask that you just maybe follow along, and then if I've missed anything at the end, then we'll get everybody chiming in. I was trying to take notes during it, but things at some points moved kind of fast. It was more or less one of the defense attorneys, Iris, I got her name here, Iris Eaton, was the one to talk for the defense in 99% of this. And it was a 2-hour hearing, and 80% of it was her yapping on. So basically complaining about not getting discovery, stuff like that. So we're going to start. We got 30 people in here right now, so let's get started with this. I know you're all anxious to find out what's going on. So we're going to start at the beginning, and I'm going to go through the timeline as it happened and bring up what the defense has brought up, and some things that Jay is for Justice just live streamed the entire court hearing. Oh my gosh. Yes, Jay is for Justice can be in trouble for that because it was not allowed to be streamed. So I don't like calling out other YouTube creators, but I'm telling you right now, it was not allowed to be copied, streamed, anything. So I could see some trouble coming her way there. She is in the United States, I do believe. So, wow. Okay. Well, I'm following what the court has ordered, and they said we could not stream it. So I did not stream it. I know all the bigger channels did not stream it. Because we simply were not allowed. So anybody that goes against a court order, I'm sorry, but I don't have any respect for. Okay, so let's get into this. So it started with the motion was for contempt, and the defense was asking for sanctions. So basically, it was the defense attorney, Iris Eaton, Iris Eaton. I should write that down right here so I don't have to keep going back to her name. Basically took up 80% of this hearing. She was complaining and discussing about discovery. So she wanted the prosecution to be held in contempt of court and in contempt of court orders. She wanted sanctions, and wait until you hear these sanctions. She wanted the sanctions against the defense. She wanted one of two sanctions given to the prosecution, and she wanted the judge to make or choose between one of these two sanctions. She also had a non-sanction that she wanted. The first sanction was bond. She said, because of what the prosecution has done with not turning over evidence in a timely manner and disclosure or whatever they had in a timely manner, we're going to get into that. She wanted Barry's bond set today so he could get out on bond. If the judge did not want to give him bond, the second sanction that he could choose from was, if he wasn't going to give Barry bail, to dismiss the first-degree murder charge and reduce it to a second-degree murder charge, neither of which the judge is able to do, okay? And he stated even if he could, he would not do that, okay? And The next non-sanction thing that she wanted was she wanted to have a testimony hearing to talk about all the discoveries. So she wanted a discovery hearing, and she wasn't granted that either. Okay, so let's go through what happened, because there was a lot of information that I got from this, and I'm going to just put it all out there. I'm not going to watch chat right now, just so I can get this all out, and then I will jump into the chat and see what you guys have there, and we can go from there. So basically what she is saying is that she got, let me see, I wrote it down, 403 gigabytes and 2 terabytes of discovery. Now, what she's saying is there was certain discovery that she couldn't access, that they needed, and what the prosecution contributed to this was that they needed a special reader to be able to open them files. The defense really went hard here. And it was, to me, it was more or less of a temper tantrum. Like, we wanted all the evidence. You told them to, I don't know what that is for, Alley Cat. I just happened to see that pop up. Basically, she's saying that, yes, they sent us all this discovery, but we couldn't access certain parts of this discovery because it needed a special reader. She said to the judge that she went back and forth with the prosecution and tried to resolve these issues. The prosecution then went back to, let me see if I wrote that down. There's a forensics center that dealt with all this disclosure and put it onto hard drives and whatnot. And they actually went back to them and said, look, we want you to put all this stuff back on again, because they can't access certain things. They were constantly in contact with the tech department at this transcribing place that they had all this transcribed. They did everything in their power to try and help the defense get this. And they're saying, well, your tech guys should be able to download a reader, even told them what they had to download to access them files. They still had a hard time accessing them. So the prosecution redid the whole discovery again and gave a better discovery, whatever. But anyway, bottom line is they wanted sanctions because the prosecution hadn't given them the discovery in the time set out forth by an order by the judge, which, bounced back in their face because they did get all the discovery. Now, it's not the prosecution's fault that they don't have the technology or couldn't access certain technologies, as far as in readers for PDF files and voice files and stuff like that. That's not on the prosecution to babysit them and go over there and help them download stuff that they're going to need to open certain files. That's on the defense to do, okay, and their tech team. But they did go out of their way and did try and help the defense do that. I guess it still wasn't good enough. So the defense said, we didn't get it. We couldn't open it. So we want sanctions. I told you what the sanctions were that they were asking for. They wanted him out on bail, or they wanted first-degree murder charges dropped down to second degree. Well, in my opinion, by them saying that, it's like, if you're trying, they also tried to say that they don't think that there's enough evidence or anything, even with what they did get and what they could access, that they didn't see enough evidence there for proof evidence. There was none there, let alone, proof evident presumption. Great. They said it's not there. Well, that's not up for the defense to decide. That's up to, what's going to happen on the 9th, 10th, 23rd, and 24th of August. That's why you have a proof evident presumption great hearing. It's not up to the defense to say there's not enough there, because then I don't know. They're very good lawyers, so I don't know why they're trying to pull what they're trying to pull. But anyway, there's evidence that came out here. Okay. And what I got was some of the evidence that was there, that the prosecution's going to use. Okay. And it had to come out in this hearing, although I don't think the defense wanted it to come out, and really tried to keep that hidden with not wanting to divulge certain things. They just wanted the judge, can you look at paragraph 7? And that's what we're talking about. They knew everybody was watching, so they didn't want this information coming out. But I'm going to tell you evidence that has come out, and this is going to be part of the arrest affidavit, the probable cause affidavit, is Barry's iPhone, Macy's iPhone, Mallory's iPhone. Now, everything on those phones was examined, and data was taken from all those phones. Also, taken from the house was an HP laptop, an Apple laptop, and a Kindle. Okay. Now, this is one of the things that the defense was saying, like, we've got nothing from this Kindle. There's things that they got from the laptops, but the defense is saying that the prosecution only gave them selected files with, they only want us to know this, so this is all they got. The prosecution fired back and said, look it, we gave them all the discovery that was in the perimeters of the search warrant that they had. They can't go outside of the scope of the perimeters of what they asked for the search warrant for. So say there was pictures on there of, them dancing in the rain with a bunch of people. They can't give that as discovery because it's outside of the scope. So I'm not saying that was on there, but I'm just trying to give an example of, Brenda, we're getting to that. Please let me get to that. So they can't go outside the scope of what they've asked for in the search warrant. So the prosecution fired back and said, look, we gave them everything that was discoverable. Now, as far as the Kindle, apparently from what the tech department has said is that the Kindle may have been damaged in some way. And a lot of it was, Mama, I'm going to get to that. People are getting ahead of me bringing things out. I'm trying to give you the list right now of everything that electronic. I'm getting to it. Now I lost my train of thought. The prosecution says that it may have been damaged, so they don't know what they're going to be able to get off of that. Okay, so I'm going to address the spy pen. It was on the list. Suzanne had a spy pen, which there is multiple recordings of phone conversations and discussions. So I'm assuming some of that may have been with Barry. The defense is saying that it was too low. The volume was too low. They couldn't hear it. So the prosecution went to the FBI and said, look, can you enhance this? Because it's very hard to hear on it. They've done the enhancement on that. I don't know if they have gotten that file yet back from the FBI, but they let the defense know that, look, we did give it to you. I'm sorry it's not loud enough for you, but you did get it. It's not like we did not give it to you. But these are things that the defense is saying they did not get when, in fact, they did get. Okay. So no, Mama, it's all right. There's people bringing out information that I haven't got to yet. I am trying to get to it as fast as I can. I am going to go over all the stuff that was brought out. So please just let me get to it. And then we can discuss it all. So yes, there was a spy pen that was brought up that they said that they didn't have the information or the discovery on, but they did get the discovery on it. It's just they're saying they can't hear it. So the prosecution went above and beyond and got the FBI to enhance the audio on it, and they're awaiting that file to send over to the defense. Now, that's something that the prosecution didn't have to do, but they went ahead and they did it to appease the defense. And it just seems everything that they've tried to do for the defense to say, okay, we'll come and help you download the readers that you need so you can see all this information. That still wasn't good enough for the defense. They're just throwing it at them. Okay, so the defense is just, to me, pulling a hissy fit. Okay, so there's 12 devices in all. Okay, there's also Suzanne's iCloud. There's also Barry's iCloud. There's Apple phones. There's a MacBook Pro. There's a Toshiba laptop. There's a compact Toshiba. And there's also a Dell Inspire. Now, those are all the things that were listed today that they said, and there's one other person, I'm not, I might as well mention it now because somebody's going to bring it up thinking I didn't hear it, or I did. There's also a witness, MG. I believe that that is the female that used to work with Barry, that she gave up her phone willingly, that Barry was very upset that she gave her phone up. So they're saying that they don't have the discovery from her phone either. And prosecution is saying it's because we don't have it yet. So there's a few things that the defense also said that really did not sit well with me. They said, poor Barry is being held in a jail cell. They're not giving us the discovery. This preliminary hearing and proof evident presumption great hearing's coming. We just got stuff a few days ago. Well, it's not that they didn't already have that before. They just got the new version of it. So basically handing them it again with kitty gloves, and here you go, and here's what you need to download and everything. They'd already had it, but they just didn't know how to access it properly, and their tech team should have been able to access that, but couldn't. That's not the prosecution's fault. So they were asking for all these sanctions, which the judge denied. The judge did not give any sanctions on the prosecution at all. What the judge did say is, with the mirrored copies of the iPhones, okay, that the prosecution is making new files for them because they said that they couldn't access some stuff. So they basically went in with kitty gloves and did all the stuff that the defense is supposed to do. They went ahead and, out of the goodness of their heart, did that for them and furbished it to them again. Okay? So that was thrown out. The spy pen recordings. Okay. The prosecution did go to the FBI and they did create a better file on it, enhanced it for them so they were able to hear it. The defense was going, oh, well, they must have listened to it with headphones. Okay, well, put a set of headphones on. But no, anyway, so the prosecution, trying to appease the defense again, went to the FBI and said, could you please enhance it a bit so the defense can hear it better? They're to provide that within 7 days. Apparently, from what I got from the prosecution's office, is that they were going to provide that today. The violation that they were in with the Suzanne's iCloud, that has been remedied already, so that was thrown out. Now, the discrepancies, the judge said there's a lot of discrepancies in what they did and did not get from the laptops and Kindle. So, the judge basically told the prosecution within 7 days, give a status to the court of what has been given and what hasn't been and what may still be coming, so they know where they're at with that. Also, the 9 devices in receipt from Rocky Mountain, that's the Rocky Mountain Forensics company, that they're the ones that went through all the cell phones and made the copies and everything. They want some kind of update from them within 7 days as to what is still going to be coming and what has already been given, and then copies of what was given and when, so they know when that was done, because the defense seems to be pulling a hissy fit on that. So regarding the witness MG, her cell phone, the results are to be provided within 7 days to the defense regarding that, if they're available to the prosecution right now. If they do have that in the receipt, they have to provide that within 7 days to the defense. Also, there's 26 photos that the defense has said were thrown in front of Barry Morphew during one of his interrogations. I would be anxious to know what those 26 photos were of. But apparently, the way the defense talked about it was they had brought Barry in for questioning and they shoved these 26 photos in his face or laid them out in front of him and basically questioned him on these photos. Now, the judge did order that, if that was done by the FBI, by the way. So the prosecution was ordered by the judge that if they have that in their possession, that they are to turn that over to the defense within 7 days, or to request that the FBI provide a copy to the defense within 7 days of those photos. They want to know what photos were thrown in front of Barry Morphew's face. The body cam footage has been resolved already. And okay, so the other thing that is still in dispute, which the judge said they can ask for a pleading on that to go over the files regarding emails between law enforcement and other agencies that defense is saying that they don't have copies of, that they only have copies of emails from the prosecution to LE saying, can we have this? Can we have that? Whatever. I think there's more emails there than that. I think she's going on a little bit of a fishing expedition there. But she's not satisfied that those are the only emails that are there that they received. Now, a lot of that isn't going to be included in Rule 16 that they have to disclose. Like if they, send an email to the FBI saying, hey, we got the file. We're unsure of this. Should that be included? Shouldn't it? Like stuff like that. I don't think they have to disclose in discovery, because I don't think it's basically memos that aren't included in this Rule 16. But I think that she's wanting them. We've seen another lawyer, Mark Means, try and do the same thing. I don't think she's going to get that. So all in all, when all was said and done, the prosecution was not, even though the defense gave to the judge all these other court cases where the prosecution was sanctioned because they didn't do certain things right or late discovery or whatever. She read about 8 different cases, 8 or 9 maybe, where they were sanctioned. The judge still did not sanction the prosecution's office. From what I see of this, you guys, there's a lot of discovery. There's terabytes upon terabytes upon terabytes. The prosecution has said that there's still an ongoing investigation going on because Suzanne's body still has not been found. So there is constantly more information coming in. As that information is coming in, they are passing that on to the defense, even though at this point they don't have to. They've got, I think, 28 days to do that from the time they get possession of it. But out of good faith, they are passing it along right away. Also, you guys, another thing that I found admirable was, even though the defense was being very nitpicky with the prosecution and going after sanctions of them, the prosecution made a good point, and as to the point where even disclosure was not mandatory or not required to give until a trial date was set, they still gave that information to them early. And they didn't have to give certain information to the defense until a trial date was set. And the prosecution said, we gave it to them anyway because we have it, might as well give it to them. Even though they did not legally have to yet, they still gave it, okay? And as they did, they went above and beyond and outside of the scope of what they were required to do from the prosecution's office in trying to help them fix all their, issues that they were having with viewing certain documents or audio files. They basically went right to the lawyer's office and said, look at this, here it is, I'll pull it up for you. This is what you got to download to see this file. This is what you got to download to see this file. They went out of their way to try and appease the defense. And in my opinion, you guys, the defense was looking at any way, shape, or form that they could get to have sanctions against the prosecution. And the 2 sanctions that they wanted the judge to choose from was, number 1, either let Barry out on bond, set bond, okay, citing that this was a violation of his constitutional rights to bail, etc., which it's not, okay, because he's being charged with a capital offense, and they can seek the death penalty in this because the incident happened before the death penalty was abolished on July 1st, 2020. Even though he was not charged until later on, the offense happened before the July 1st, 2020 cutoff. So the judge did state today that he is still facing a capital murder charge, okay? or could be facing the death penalty. So he's not entitled to bail. And then they said, well, if you don't want to give him bail, then we want you to dismiss the first-degree murder and reduce it to a charge of second-degree murder. Well, why would you ask that your client have a murder charge at all if you're saying that there's not even enough evidence there to show that Suzanne is even dead or that Barry did this? So they're very conflicting in what they're saying. They're very contradictory. They're contradicting themselves. By what she first said was, by what we've seen, there's no evidence that Suzanne's even dead or that Barry did it if she is, and that, blah, blah, blah. They haven't found her body, so they can't even say she could be off running around somewhere. There's no evidence that she's even dead because they haven't found a body. Now, with that being said, if that's what you think, then why are you asking the judge as a sanction, if he doesn't give Barry bond, then why would you want him to dismiss first-degree murder and reduce the charge to second-degree murder if you don't think your client is even guilty of murder, which you stated at the beginning of your argument in this case? So, I mean, she's kind of contradicting herself, and the judge seen kind of, I think, through it. And I think that the judge also seen that the prosecution was going outside of normal scope to even, instead of just here's the discovery, they've tried to help them in the aspect of being able to access files. Like, we're sorry you don't have the same equipment we do to access those files, but this is what you need to access those files. You can't say, please give us everything and give it to us quickly and then condemn us for how we've given it to you. They were able, once they downloaded these readers, they were able to see the files that they were trying to bring sanctions against for not getting these files. Okay. So there's a spy pen, you guys. We're going to get into that now because but there's one more thing that I want to share with you guys that the judge said right at the end. The judge says because the courtrooms are open now and he can have, I think, 20 to 30 people in his courtroom from the public, that there will be no more Zoom or WebEx coverage of his court proceedings, which means we will not be able to see the proof evident presumption great hearing, and we will not be able to see the preliminary hearing. So we won't, as YouTubers, we won't even be able to watch it ourselves, let alone not stream it. There's not going to be a stream. He is not going to be doing this anymore. So that kind of upset me a little bit because I would have liked to be able to watch the proof evident presumption great hearing and the preliminary. I think it's their way of blocking us from seeing what evidence they have against Barry, because it would have came out, a lot would have came out in the proof evident presumption great and in the preliminary hearing. A lot of that evidence would have came out, and now we're not going to see it. The only people that are going to be seeing it is whoever can get into that courtroom. I believe that there's only going to be 20 to maybe 30 spots available for the general public. So we're going to have to rely on whatever public can get into that hearing. And we're going to have to take it secondhand now. So we can't even watch it being streamed. He is closing it off, whereas a lot of the other courts are still doing streaming. He says that he needs to pay attention to what's going on in front of him. He doesn't want to have to pay attention to what's going on the WebEx. Well, he doesn't have to, right? They can have a pool camera in there, which I do think that the media is going to fight for. I think they're going to fight for a pool camera. So yes, the public is going to be able to go in, but it's going to be very limited because they have to keep 3 feet apart. And I don't know how they are going to do that, if they're going to have a raffle to pulling, put your name in the hat. And if your name's pulled, do you get to go? I don't know how they're going to do it, but it's going to be very limited. Also, what the defense tried to do was try to limit the time that the prosecution had in this proof evident presumption great and preliminary hearing, because the prosecution is saying that they have 18 witnesses, and we kind of know how I have a funny feeling of who's going to be called in that. I don't have the list. Nothing is being even put into the record. And this is what I don't get, you guys. I'm going to look at chat now because that's basically what I had to share with you. But I don't know why Barry Morphew is getting special attention here and special favors. Because in the Letitia Stout, in the Lori and Chad Daybell cases, we see that the record, we can go online and see what's put into the continuing record, into the court file. We can't do that with Barry. Okay? So we didn't even know. There's been other court hearings that have happened over the last month that we weren't even aware of. Okay? There's been all kinds of things filed into the court record that we're not aware of. We can't see it. I go into that court record daily. I can't see anything since the judge made the ruling that everything's to remain under seal. So why is Barry getting this blanket coverage of we can't see anything that's being filed in the courts? Now we're going to not be able to watch via WebEx or Zoom. You know, like, why is he getting special treatment? Okay. Letitia Stout is in Colorado too. Everything that's been happening in her court case has been put into the record and we can see it. Okay. Her court appearances, we've been able to see it. Why is Barry Morphew getting special treatment? I don't think it's right. I really don't think it's right. And it doesn't matter how much money you have. The law is the law. The right to public access is the right to public access. It doesn't matter if you're poor or you're rich. Well, it shouldn't matter. But in this case, it's looking like somebody has friends in high places in the judicial system, because I don't know how they can stop the public from being able to see what the public has a right to see. And I'm talking about things not being visible in the court record. I don't get it. So I don't know how it's being done, but all I know is I see special treatment here, and I don't get why or how they're getting away with that. So I'm a little upset that I'm not going to be able to stream that for you guys on the 9th and 10th and the 23rd and 24th. And the way things are going is I don't even think that we're going to be able to see the arrest affidavit. I don't think we're ever going to be able to see it. And I just don't think that's fair to the public. So what are your guys' thoughts on that? Yeah, where is she? But we do know that there was stuff in Suzanne's cloud. There was also something that Suzanne had was a spy pen. Okay, that speaks volumes, you guys. Why did Suzanne feel the need to have a spy pen and record things? Okay, and these are all things that I mentioned that are part of the arrest affidavit. Ken says once he is convicted, the records will be released. I don't know about that, Ken. I don't know how this is going to work, because I'm just, like I said, I'm in Canada. So, but seeing what's going on with these other cases in the US with the Lori Vallow, Chad Daybell, Letitia Stout, and that, everything is in the continuing court record that we can view online. Why can we not see Barry's? Hello, Angel Girl. So hello, everybody. Thank you for coming in. So there's a lot of unanswered questions here. And I don't know. I don't even know, you guys, if the media filed motions because we can't see anything. We can't even see that. So Ken says any influential person that's backing him will want to wash their hands of him once he's convicted. Yes, absolutely. Okay, so Mama Shanshan says, I'm checking into a spy pen. This is interesting. Makes so much sense when one feels threatened. I'm assuming it looks like a real pen, Mama Shanshan, does it? You're looking it up? Maybe you can tell us that. Maybe that was her way of being able to hide it, carrying around a pen. He wouldn't think nothing of it, right? Blazer fan says special treatment for the daughters too. Absolutely. Absolutely. Because you see that they say, oh, well, the information that's coming out and the details of the arrest affidavit could, harm the daughters. Well, they didn't care about that when they released the arrest affidavits for Chad Daybell, Lori Vallow. What about their children having to see what they're being accused of? Like, why is this guy getting special treatment? I don't get it. Leslie is in the UK and she says, I'm in the UK and we have never been able to see a court case or look online to see what people have been charged with, but the newspapers give us that information. Leslie, it's the same here in Canada. You can't go on into a court file like we can in the US. I'm in Canada. We can't do it here either. The US seems to be very open and transparent with putting court documents up on the web for anybody to be able to view. But we can't do that here either. You can request it. You can do a freedom of information request, but it takes months and months and months and months to get it sometimes here in Canada. Yes, I find that very strange too. Angel Girl says, Barry probably gets steak in jail too. Ridiculous. He is getting special treatment. Yes. To me, he's getting special treatment. I could be wrong. But from what I'm seeing, let me know what you guys think. Press 1, hit that 1 button if you think that this is ridiculous, the treatment and special treatment that Barry Morphew's getting. Hit that 1. Hit number 2 if you don't think he's getting special treatment. Yeah. TF20 says that, are they still at the beginning stages of this case? No, they're well into it. But even the other cases, you guys, right from the beginning, as soon as they're arrested, usually within the first week or so, the arrest affidavit is released. We see that in the Letitia Stout, Lori Daybell, and Chad Daybell case. We've seen it all released fairly quickly. Yeah. See, the majority thinks that he is getting special treatment. And like I said, when it's, when everybody wants and media has requested copies of it and they're denied and the judge has sealed it, the judge did seal the arrest affidavit for Letitia Stout until they could give it to the family members and let the family members go over it. But he only gave them 3 days until he was going to release it. So it was still released fairly quickly. So I don't know why we can't see, but we could still see all the court documents. Okay. Right from the beginning before Letitia, even, I guess right from day 1, when she was arrested, we started seeing the court documents. TF20, yes, they are still arguing that they didn't get full disclosure, yet they have gotten full disclosure. There's certain things that they still haven't got yet because the prosecution doesn't have it yet. If the prosecution doesn't have it in their hands, they can't forward it on. The prosecution also let them know, look, we haven't given you stuff that we didn't have to give you yet because there's certain timelines that they have to give stuff for, like a witness list has to be given just before, once the trial date's set. Within so many days, they have to give their witness list. Well, they've already got their witness list. So, I mean, that's something that the prosecution didn't have to give yet they've already given it. So, I mean, I don't think the prosecution is trying to hide anything or try to, the defense also said that the prosecution was trying to delay things. And the prosecution out and out said, oh no, we're not trying to delay nothing. We're set and ready to go on the dates that have been put aside for this case. So, and you could see the defense counsel shaking her head and making funny faces and that. But they tried to actually say that the prosecution was trying to delay this preliminary hearing. I actually think that the defense was trying to do that, and the defense was trying to set things out and put the prosecution past the deadline so the case would be thrown out. But the defense doesn't want to prolong this, because when they do, the date for discovery starts again from the time they put the case over. So if they try and change these dates, they're giving the prosecution extra time too, and they don't want to do that. So how about the narrowed witness list, but defense doesn't have to provide? I think the defense said that they have a couple of expert witnesses that they're going to have sitting with them. But the witness lists don't have to be given until a trial date set. They can say, look, these are the witnesses we've subpoenaed. We may or may not call them all. But the defense was trying to limit how much time the prosecution had in this preliminary hearing and proof evident presumption great hearing. They were trying to say, well, Your Honor, they're saying that they have 18 witnesses. I don't think that's fair. I think the 4 days that have been allotted for this should be divided equally. Well, if you only have 2 witnesses that you're going to call, and the prosecution has 18, I don't think the time is going to be divided equally, because you don't have as many witnesses as them. You're going to get your witnesses in, but the prosecution has a right to bring every witness that they want to bring. You can't limit their time. So if it goes over, it goes over. Like, you don't want your rights for Barry being taken away, but you want to take away the rights of the prosecution to give everything that they need to give to solidify that this is going to go to trial. You want to limit what they can do, but you don't want to be limited to what you can do for Barry. Like, there's a lot of double talk there with these attorneys. And I picked up on that real quick. Like, hey, we want this and we want that and we want this and we want that, but we want to take this from the prosecution. We don't want them to be able to bring all their evidence, because they're trying to limit the evidence that's going to be brought in at this proof evident presumption great and the preliminary hearing. They're trying to limit the time that they have so they don't get all their evidence in that they want to get in. So the judge doesn't say, oh, well, you don't have enough evidence, so we're going to have to throw this out right here. No, you can't do that. So don't ask for more than what, you're getting. So if you want you want the time to present everything for your client, then you've got to give that to the prosecution. And each side is going to get it anyway. If you have X amount of witnesses and it's going to go over the 4 days, then it goes over the 4 days. They're going to have to put more time aside for it. So the defense is trying to be shady. Yes, made me sick too, Maui girl. Barry is sitting there, and the prosecution can go home and use their own toilet and eat at their own dinner table. Barry can't do that. Well, maybe Barry should have thought about that before he did what he did. I've got no compassion or empathy for Barry Morphew. You're sitting right where you should be. Yeah, they're trying to paint Barry as a victim. Barry is far from being a victim. Well, the defense is biased, and that's what they should be for their client. But the steps that, the things that they brought out is pretty Mark Means. You know what I mean? Like, these are really good lawyers that he's got. So why they're stooping to Mark Means's ways is beyond me. It's not a good look for them. It's not a good look for them at all. And I think they upset the judge with this. They were not happy with what the judge said at the end of this, when the judge did not impose any sanctions and basically gave them 7 more days to give everything that they've got, anything new that's come in, give it to them. And not dropping his first degree murder to a second degree or giving him bail. Yeah, they were really like, are you kidding me? Well, we're not asking for it to be dismissed, she says, which we could, because the prosecution, in our opinion, is in contempt of court, of a court order. So we're not asking, although we could ask for you to dismiss this case, we're not asking for that, but we're asking to either set bond or drop his charge from first degree murder to second degree murder. Those are the sanctions that we would be asking for. Like, are you, like, is Mark Means wearing a costume there or what? To look like a female? I don't know, but it just seems so Mark Means to me. And like I said, it's very concerning for me because it's not a good look for them. They're very, like, I don't want to demean these lawyers in any way, shape, or form, but when you start acting like you just came out of law school with some of the things that you projected today, it's not a good look for these lawyers, because these are very high profile lawyers and they're very good at what they do. So you're not putting a good look out there for yourself. Yes. Suzanne's inheritance is paying for Barry's defense. I think that's all been frozen. Lena Jacobs, didn't they get someone off on a technicality? I think they are just throwing things out there, hoping something will stick. Well, that's what I'm saying. They're on a fishing expedition. I have no idea. I didn't look into them that deeply. But I do know that from what's being said that they are very good lawyers, they're very high profile lawyers, and they're supposed to be very good. And that's why I'm saying with some of the things that they said and tried to pull today was very Mark Means. You know what I mean? So, and it's not a good look for them. I think they lowered their they lowered their credentials there a little bit by doing what they did today in some things that they did today. But it did give us a look into what they do have as far as the electronics and stuff. So we do know that Suzanne, so some of the things that we're probably going to see in this arrest affidavit is there's going to be some recordings that Suzanne did secretly with a spy pen. Okay, so that's new, that's come out, the spy pen. She was smart. She knew she was in danger. That says a lot, okay? Like, to those of you who are married, do you carry around a spy pen with you if you're not afraid of something happening to you? You know? So that's very telling right there, okay? Also, they said that there is stuff in Suzanne's iCloud. Okay, so everything that was used in the arrest affidavit, okay, is what they spoke about, okay? So what is there? What are they talking about? They're talking about Barry's iPhone, Macy's iPhone, Mallory's iPhone, and the data and stuff that was taken from there. So obviously, if they are mentioning those 3 things, they have evidence on those 3 things. So I'm anxious. What is the evidence on her daughter's cell phones that they used? Now, don't forget what I'm talking about right now, you guys. These are things that they used in the affidavit that they did to arrest Barry. They used things from Barry's phone, Macy's phone, and Mallory's phone. So what does that tell us? That tells us that there's something there that was going on on these phones that has given the prosecution reason to believe Barry's involved. So what's on these daughters' phones? We know there's got to be something on Barry's phone, but what is on these daughters' phones that could have been used to arrest Barry? Keep that in mind for everything that we touch on. The HP laptop, the Apple laptop, and the Kindle. What was on those that they used in their affidavit of Barry's arrest? There had to have been stuff on there that they found to arrest Barry. Also, the spy pen and Suzanne's iCloud. There was stuff on that spy pen and Suzanne's iCloud that was used to arrest Barry. Okay? There's 12 devices in total. Those are the only ones that they mentioned. Okay? Then at the end, the judge blurted it. There's a black Apple iPhone that they got information off of. There's a MacBook Pro that they got Apple information off of. There's a Toshiba laptop and a compact Toshiba laptop that they got information off of, and a Dell Inspire that they got information. All those things that I just listed to you are being brought up because there had to have been information on those devices that led to arresting Barry. Those things were used to gain evidence that they used to arrest Barry. Okay? That's not everything they have. Okay? They probably have lots of other stuff. But the information contained in the arrest affidavit was gotten from these devices. So what I can just see it now, hundreds and hundreds of things listed there of what they got off of all these devices, which when they put that all that evidence together, came together like, oh my gosh, they're talking about this, they're talking about that. That coincides with this. So there's information on the girls' phones, Barry's phones, the laptops, the Kindles, Suzanne's iCloud, Suzanne's spy cam, these other Apple phones, the MacBooks, the Toshibas, the Dell Inspire. There's information on all of those things that they used in their arrest affidavit, and probably stuff that they found there that they investigated further. We don't know, you guys, but we know that those things are very important with proving that Barry did something to Suzanne, or they wouldn't have been talked about. Let me just look up. Yes, that's a lot of devices. There's 12 in total. And those are the only ones that they're speaking about right now. I'm sure there's a lot more. And also, MG, what was her name? The girl that worked with Barry that gave her phone up, because that's who they're talking about. Is her initials MG? Anybody? Does anybody remember? I mean, I could look it up back in my books of information here that I got, but it would take me forever. Is a spy pen voice activated? I believe it can be. Morgan Gentile. Okay, so that's her then. Thank you. Gailey, thank you. Morgan Gentile. Because it says also the defense was discussing witness MG. She is on the prosecution's witness list. They've not been provided anything that was found on her phone. So the judge ordered that to be also given within 7 days if they have it. Also, you guys, this is big. This is something else I forgot. There's photos and hotel surveillance footage that they also used in the arrest affidavit. Sorry, you guys, totally. I just seen that now. Let me see if I missed anything else. The body cams, there's body cams that were used, and hotel surveillance photos and videos that are also part of the arrest affidavit. Well, this goes, thank you for your comment, Nancy, but this goes a little bit more than just domestic violence. But yes, they've also got hotel surveillance and photos that they used in the arrest affidavit also. So the prosecution has said that this is still very much ongoing. But that spy pen, I would like to know what was on Suzanne's spy pen. Holy cow, did the price go up? They used to be 99 cents on the back of comic books in the 60s. Well, Compu, things have really gone up in price since the 1960s, that's for sure. Yes, that is a lot. If it's ongoing, is that why they haven't? No, I don't believe that for a minute. The prosecution had no qualms of the arrest affidavit being released. They didn't care if it was released or not. It's the defense that doesn't want it released. And that's why I'm saying when the prosecution isn't objecting to it being released, but the defense is, and they're getting that against the public's right to know, against the media, like news, stuff like that, they're taking away their rights to be able to see that, the general public's right to see it. And the prosecution didn't care if it was released or not. So why is Barry Morphew getting special treatment? It is crazy that they have enough to prosecute. See, we don't know what they have. We don't know what's on that spy pen. We don't know what Stan saved in her iCloud. There's going to be conversations that she had with her friends. We don't got nothing, you guys, because the arrest affidavit hasn't come out. So we can only assume at this point. But I'm telling you, for them to list all these electronics that I just listed for you, including the hotel surveillance, photos, and videos, that means that those were all part of his arrest. They used all these devices, the stuff that was found on these devices, to arrest him. So yes, they put 1 and 1 together and 2 and 2 together, and they group things. And oh, you were doing this, and the Texas came from here, and this is where we found this. And guess what? You were in that area then, Barry, because your phone shows it. And then say they found something at Suzanne's, but why does her? And I'm not saying this is what happened. Please don't say that. I'm just seeing hypothetically. Why did Mallory's phone ping on that Sunday near your home when she was supposed to have been camping somewhere else? That's just a hypothetical, you guys. Okay. That's not part of this. I'm just using a hypothetical to try and explain my point. When they put 2 and 2 together, it makes 4. Okay. So that's what they're doing. But what this does tell me is these are the things that were used to arrest him. The kids, the girls' phones, Barry's phones, the laptops, the Kindle, Suzanne's iCloud, Suzanne's spy pen, these other MacBooks and other computers, Dell, Toshiba's, the body cams, and hotel surveillance and photos. Those were all used with and helped and aided in some way of the arrest of Barry. That's the best way that I can say it. That's not all they have. They probably got DNA. They probably got, there was something else that was said. I can't remember what it was now, but I do remember hearing something in one of the prior hearings. I'd have to go back and listen again. And I went, oh my God, they found some kind of DNA, whether it be flesh, blood, body matter. They found something somewhere that with what they found would, and I'm going to give another hypothetical. if they found some, how do I say this in the nicest way possible? If they found some of her insides somewhere, even if it's a little piece of, say, the liver, you can't live without your liver, right? So whatever it is that they found DNA-wise, whether it be blood, pieces of skin, you know, they found something that says she would not have survived without this. Okay, that was just Des sending me a... She's got no cell coverage right now. She's driving. The only defense witness, prosecution witness that they did give an initial for is MG, because the defense said they don't have the disclosure from her cell phone yet. So that's the only reason they used her initials. They're not going to give out that witness yet list. That would be in the court documents that we can't even access them, let alone we're being kept from seeing the arrest affidavit. We can't see any records that have been filed with the court either, which is unheard of as far as I'm concerned, because we can see it in every other case. The judge has said no, everything's being sealed. So even though we can go into, say, Letitia Stout or Lori and Chad's and see everything that's going on and being filed and being fought about, we can't see that in Barry's. It's being hidden. But I'm anxious about this spy pen that Suzanne had. What is on that spy pen? And why did Suzanne feel the need to walk around with a spy pen? I can see why she would get a spy pen, because Barry wouldn't think nothing of it if she had a pen in her hand compared to maybe a recording device. You know what I mean? So she was smart. She knew something was up. Suzanne knew that something could happen to her. And I think it's all going to be proved right there with why did Suzanne have to carry around a spy pen? If everything was honky-dory like Barry said, why was Suzanne carrying around a spy pen? Right? Yes, please smash that like button. Let people know that we are live. The defense only said that they have 2 experts that they're going to be calling for the preliminary and proof evident presumption grade hearing. But we're not going to be able to see it. I hope that there's a pool camera in there for news media that we may be able to see or stream from. But they're not doing it with the court set up on Zoom or WebEx or anything like that. So we're not going to be able to see it that way. Now, the media is probably going to fight to have a pool camera in there. And if that's the case, then we can stream it from there. So cross your fingers, you guys, and hope, because if we can, if they get a pool camera in there, then we'll be able to stream it from that pool camera. And I will be able to bring it to you. If not, we're going to have to wait to see what the news says, right? Or if we've got somebody from our subscriber list who is in that area that can get in for these hearings and maybe take notes for us, would be great. Okay, so Des is back. She lost connection. She's driving. High hopes for the press getting court action to all of us. Yes, because I just really don't think that it's fair that the judge, and he made it quite clear just before they ended everything. He says now to everybody, because he's seen how many people were in there watching this hearing today. He says, I'm going to let you guys all know that this is the last one. There's not going to be no more of this WebEx or Zoom or nothing in my courtroom. So the only people that are going to, from the public, that are going to be able to see this now is people that can get into the courtroom, or if there's a pool camera that's going to be hopefully in there for media to stream. Hopefully. And then hopefully we can get access to that stream. So, okay, so that's it, you guys. That's what we got. The defense is not happy campers. They didn't get any of the sanctions that they wanted. They wanted either Barry out on bail, or they wanted the judge to knock his charges from first degree to second degree murder and stuff like that. They didn't get any of that. And what they did get is the prosecution has been given 7 more days to give the defense any information or any disclosure that they have got that they don't think that the defense has gotten to this point. So that's where we stand with it, you guys. And we'll see what's going to happen with the proof evident presumption great and the preliminary hearing coming up. Hopefully we can get a link to a pool stream that the media hopefully gets, hopefully, because the judge is not going to be allowing any more streaming of this on in his courtroom. And I mean, it's not even, he doesn't even have to watch the stream because he's going to be having everybody there live. He doesn't have to watch the screen anymore. So it really doesn't make sense, his reasoning for it. He says, I can't pay attention to the WebEx screen and pay attention to what's going on in my courtroom. Well, you don't have to pay attention to the live stream because you're going to have everybody in your courtroom. That's just for all of us to see. He's going to have the prosecution and Barry and everybody there live. So he doesn't even have to look at the WebEx screen. The only thing the WebEx would be there for was that so that we could all see it, not for him. So I don't get it. Like, he kind of double talk there. Like, I don't want to have to look at the WebEx screen. Well, you don't have to. You know what I mean? Like, he can put, like he did today, the blanket mute on everybody, and only allow, you know, the participants of the case to have their mics on. So I don't know. I just don't get it. I just think that there's a lot of favoritism towards Barry being shown with this blanket immunity, with not blanket immunity, but this blanket, the judge likes to hear himself talk. I think he did pretty good today. With the sealing of everything, I just don't know how Barry Morphew is getting special treatment with things being put under seal the way they are. And now we can't watch via WebEx. So I don't know. I don't know how Barry's getting that, but there's questions. It's raised red flags with me. And if it's raised red flags with little old me, it's got to have raised red flags with media and the other bigger channels that like Duty Ron and Police Off the Cuff. If you guys haven't subscribed to them, head on over there, because these are retired FBI agents that have some good information that come out there, okay? Also today, you guys, is EquiSearch is starting their search for summer wells today. If you are in that area and you do happen to see them out there, please don't report it on Facebook or YouTube or anything as to where you're seeing them. But I believe that is a good go in the right direction in trying to find summer wells. So they are on it. They are in town and they are doing their searches on that. And let's hope to God that, and pray, say an extra prayer tonight, you guys, that they can find little Summer and bring her, I don't want to say home, but at least bring her back to all of us that love and care about her and are praying for her to be found so she can have a proper burial. So with that being said, you guys, I'm going to let you guys go. I got to get going on supper here. It's 4 o'clock, going on 4 o'clock, 20 to 4. And I want to thank you guys all. There was another YouTuber streaming this hearing. I thought you guys weren't allowed. No, we were not allowed. And somebody at the beginning of this did say the YouTube channel that streamed it, and I think that they could be in some hot water. The judge made it very clear that this was not to be recorded, streamed, nothing. So whoever did that, and I'm not going to mention their name, if you want to see who it is, go back to the beginning of the live chat and you'll see who did it. But that's a big no-no. And I got no respect for people who do not feel the need to follow court orders. Okay, so with that being said, you guys, I'm going to, yes, Des, the judge made that clear that Barry is eligible for the death penalty. It can be a capital murder case because the incident happened before the death penalty was abolished. So with that being said, you guys, I'm going to let you all go for now. Get back to what you got to do. I want to thank you for all being here and being part of this and having your input and everything. I very much appreciate it. If there is anything, if you guys were in that court thing today and I missed anything, please put it in the comment section once this video is put over to my YouTube channel. It will take a bit of time for the live chat to be uploaded onto YouTube, but you can certainly put anything in the comments there. If I missed anything, please feel free to put it there. Like I said, I tried to take the best notes that I could, but I'm sure there's things that I missed. So, but yes, he is eligible for the death penalty. And that's why they're trying to get it knocked down to second-degree murder. Nice try, you guys. But anyway, I will let you guys go for now. Thank you very much for supporting the channel and coming out and chit-chatting with us. I appreciate each and every one of you. Thank you to my mods for coming out. I love you too, sis. I love each and every one of you. And I want to thank you all for coming out, especially my mods for being here. I really appreciate you guys and everything you do. So until then, you guys, please take care of yourself. If anything else comes up, I will be sure to let you guys know. Okay? Take care and bye-bye for now.